Good morning and welcome to the Justice Committee's 26th meeting of 2019. We have apologies from Liam MacArthur. Agenda item 1 is a decision to take items 11 and 12 in private, which are to consider our pre-budget scrutiny report and our work programme. Are we all agreed? Thank you. Agenda item 2 is an evidence session on the Scottish Biometrics Commissioner Bill. I refer members to paper 1, which is a note by the clerks, and paper 2, which is private paper. I welcome our witnesses to the meeting, Detective Chief Superintendent Sean Scott, Police Scotland, and Tom Nelson, Director of Forensic Services, Scottish Police Authority. Can I thank the witnesses for their written submissions, which, as ever, are extremely helpful for the committee in advance of taking our formal evidence. We now move to questions. I'm going to start by asking you if you could explain the process for collecting, storing, using and retaining biometric data. We know this is complex, but it would be good just to explain how that works in practice.
Okay, thank you, Chair. So, obviously grateful for the opportunity to provide some oral evidence this morning. So, you know, in the criminal justice process, the acquisition, retention and use and then the disposal of biometric data effectively starts with people being brought into custody. So people are brought into custody as suspects or arrestees, and we have the power obviously to take DNA and fingerprints within that mechanism and photographs within the custody. These biometric samples are ultimately processed, and then thereafter, depending on the criminal justice outcome of the inquiry, i.e. conviction or not, then that dictates how the retention and or the weeding of these samples are processed. And in that mechanism, the DNA and the fingerprints go through a data process which is loading onto databases, be it the Scottish DNA database or the National DNA database or the Ident1 Home Office fingerprint live scan system, so which you know is more into Tom's area of business, but that's effectively it. But also we have ways and means through crime scene investigation, where we you know, pick up samples from crime scenes and they then get processed obviously through the same kind of system, whereby they're profiled and loaded onto databases and recorded appropriately, and thereafter as well we'll go through weeding protocols, if you like.
So in terms of the who, would the custody sort of evidence collected be by the police initially? And
sorry, could you say that again, please?
In terms of who does the collecting initially? If it's for someone in custody, would that be the police initially?
Yeah, the officers or the custody staff within the custody areas do that process of that collection.
And anything you wanted to add, Mr. Nelson?
Yeah, I'll just maybe mention about, obviously, in terms of DNA, we have our own Scottish DNA database. That database is based in Dundee, and that loads samples onto the National DNA database, which is obviously a UK database. Fingerprints is slightly different in that we don't have our own Scottish database, but we actually load our samples onto the National Ident1 fingerprint database. So there is a slight difference in both DNA and fingerprints. That is a historical issue going back many, many years, and obviously DNA is a fairly new science. And whenever it was under the forensic service environment, then we brought in that Scottish DNA database. But the process then thereafter is very, very similar.
Yeah. So is that an area that there might be an overlap then?
So we will obviously search initially over samples on the Scottish DNA database. And obviously if we get a hit, then there's no need to actually then load that sample onto the National.
Yeah. Is there any other area there might be any overlap in the process?
Not that I'm aware of.
Not that I can think of, no.
Okay, I think we move on to the next question, Rona.
Thank you. Yes, good morning. Just sort of following on from that line of questioning, you've talked about the process of collecting the data in its various forms. Can I ask you about the control of that data at each stage? Who actually takes ownership of it? And then how is it shared amongst the different services, such as the Crown Office, the courts, defence solicitors, etc.? It's just important for us to know what happens to it along those various stages.
Well, the actual physical sample, if you like, so that is effectively a thing. It's a physical thing. It's an item. It's a production, and then the process of then creating the data. So the data isn't actually the thing itself, the physical item. It's how that's processed and then recorded on a database, as Tom says, whether it's the fingerprint database or the DNA database, so that then that is loaded on. We retain the physical samples, if you like, but the data then is on a database, and then it's alluded to in thereafter in the police reports to the Crown Office. You know, they receive that information, but they don't have control of the databases, if you like, so that we report what we have. Any analysis that's then done around the samples, the fingerprints or the DNA, is then part of that report, and we get reports from Tom's staff about the results of fingerprint analysis or DNA analysis, and then that's reported to the Crown. So they're effectively, the data is retained in the database. Any physical samples are retained by ourselves or the SPA in the lab, and the Crown Office receive a report to that effect.
So if I'm understanding you correctly, the data remains your responsibility because you share it on, but it's
Yes.
still your responsibility.
Effectively, yes.
Okay.
Would you agree with that, Tom?
Yes, that's correct.
That's correct. Okay, thank you.
I think it would be helpful to tease this out a little bit more, if you could explain what the situation is currently with regard to the governance of the process involved in collecting and using the biometric data. I suppose really what we're getting at, in effect, who has oversight of these processes with regard to Police Scotland and the SPA, and who retains overall responsibility in these two organisations for the data collected. Or
So the data itself, we're effectively joint data controllers, in that obviously both myself and the Chief Constable is responsible for that data. The data, as I say, is stored on the National DNA database and also the Scottish DNA database, as is the fingerprints on the National Ident1 database. And it's through a working relationship with Police Scotland and a National System Support Unit that those samples are then managed.
and so governance, which is maybe a little bit different.
So overall governance effectively sits with the Scottish Police Authority, and they oversee that whole process.
That's helpful, thank you. Shona.
Morning. In the written evidence, the SPA says that there's evidence of strong existing governance and practice within Police Scotland and the SPA around the use of biometric data. So I guess my question is, could you elaborate on that, and most importantly, explain in your view how the establishment of a commissioner will further strengthen this area? I mean, I guess, like, what difference will it make? What, in your view, what will the main difference be?
So obviously the practices of Scotland was alluded to in the S. Marper case, where the evidence was that the processes that we have in place and obviously the retention was exemplar in terms of the processes and the timelines. Also was picked up in the HMICS inspection report in 2016 that the governance was strong between Police Scotland and obviously SPA. But one of the things we've always felt we needed is a biometrics commissioner, and that is certainly something we within Forensic Services have been looking for a number of years now, and we're really pleased obviously that this bill has come forward now to allow us to have a commissioner in place. One of the main reasons I believe where the commissioner will add significant value is particularly around public awareness. I think it is crucial that we keep the public aware of obviously what we're doing with the data. Because obviously there are new technologies coming on board, in, for instance, DNA. In a couple of years we potentially could be looking at areas which may give more characteristics like hair colour, eye colour, and we believe that needs a public debate to make sure that what we're doing is what the public are wanting, but at least they understand why we want to go down that particular direction. So we believe that the Commissioner can certainly begin to lead that public debate on where science is going in the future.
So really what you're saying is that the governance and practice at the moment, in your opinion, is sound, but with a look to the future and of that public support for areas perhaps unknown at the moment in terms of the development of
very
technology.
Much so. Sorry, very much so. To me, it's all about keeping the public informed, and keeping them engaged. The last thing we want is them to lose confidence in our databases. So that is crucial. And at the end of the day, we're public servants, and therefore we want the public to be involved in that discussion. And therefore, that's certainly one of the key roles we feel that the Biometrics Commissioner could do. We also believe the codes of practice are crucial in moving forward. Certainly, whenever I was part of the advisory group, independent advisory group, we developed a draft code of practice, and that went out for public consultation. And certainly there's very strong support for that code of practice because it does go into very much the detail of how you will deal with new sciences or new technology. And we live in a world where technology is changing all the time. And I certainly am of the view that technology should be validated and obviously a full proper process put around that before it is used. And that's something I think in the codes of practice and working with the Biometrics Commissioner that will bring some benefit to Scotland.
Okay.
I think if I can just come in there as well, thanks, Tom. On the point Tom made about public awareness as well, you know, ahead of any decision about the bill, we're doing a bit of proactive work within Police Scotland about notice to people that come into custody. So effectively, you know, biometrics and what happens with them more directly affect those that come into custody than, you know, any other member of the public, you could argue. Excuse me. So we've composed and about to introduce a notice to people about why we take it, what powers we have for taking it, what happens to it, what their rights are. So a fairly sort of, you know, simple but direct information sheet, if you like, so that, because traditionally up to now, you know, we do it, but people quite often don't ask what we're doing with it, but they don't really know what happens to it and why we're taking it and what their rights are. So we're now introducing a notice, a bit like, yeah, for your solicitor access rights, that you know clearly what your rights are in terms of biometrics. So we're about to introduce.
And that will be routinely given then to every.
Yes. So every custody, every person that has biometrics taken from them will be provided with this information, so know exactly why we're doing it, what happens, and what the rights are.
Thank you.
Rona.
Thanks, Convener. So, as we understand at the moment, the uploading DNA and fingerprint data is done on a voluntary basis. I wonder if you'd like to comment on why you think, you know, can you explain the background to that and why it's not, there's no sort of legislative underpinning, and do you think that's an effective way of collecting it?
So the fact that we in Scotland upload the data onto the UK databases on a voluntary basis. I mean, it's that interjurisdictional cooperation. I mean, you know, if we have a sample or data, DNA or fingerprint, and effectively there are many unsolved crimes out there, and there's unsolved profiles on the systems, then we clearly want to try and solve crime. So over a UK-wide basis, then we want every opportunity there is to protect the public by identifying offenders. So that voluntary uploading onto the national databases is for the wider public good, I would say. We don't have to, but it seems the right thing to do. Tom?
Yes, no, I think that's...
Just to be clear, it's not voluntary for the suspect, it's voluntary that you're doing that, you're putting it on, is that...
Yes, yeah, absolutely. Yeah.
And you think that's the most effective way of doing it, the fact that you... It's just part of the process for you?
It's part of the process, yes. Yeah. I mean, as Tom said, if we got a hit, for example, in DNA, in the Scottish DNA database, then it wouldn't be loaded onto the national one. But if we don't, then it's onto the national one to give us the best opportunity of identifying an offender. But don't forget as well, it's not just about identifying offenders, it's also about exculpating potentially as well, which I think sometimes gets lost in this, that forensics and biometrics is as much about making sure we get the right person. So that's why we do it.
I think one of the big advantages is obviously the value that these databases bring us. You know, not only in cases that are live and ongoing at this moment in time, but also in cold cases as well. You know, we've had recent cases in the last couple of months where an unsolved murder, 21-year-old murder, was solved because someone was arrested and the DNA and fingerprints taken, and that hit against the DNA database. You know, so that was able to resolve a crime which happened 21 years ago. So there's significant value in having samples on those databases.
Yeah. And can you tell me just the data at the moment? I'm presuming it's shared cross-border. Is it also shared with Europe? Is it also shared throughout Europe? And is
Yes.
that something that will no longer happen if
Yes. So yes, it's at the moment there's a process in place where it can be shared, but they don't have access to our databases. It's done through a process through the police. Yeah. But obviously, one concern for ourselves and obviously Police Scotland is if, as a result of leaving the European Union, we lose that ability, then it does obviously reduce the impact that those databases could potentially have.
And as you understand it, that will happen if we leave Europe? You will not be able to share with...
It depends on the withdrawal. So at the moment, you know, for example, in recent times, we've had 23 successes passing information or data to Europe through the Prüm agreement. So it's successful because it's rapid. It's a very quick time. The original Prüm agreement was about DNA fingerprints and vehicle registration, but at the moment it's just DNA. If we withdraw without a deal, then we'll lose that ability. But if we are part of a deal or no deal, then we should retain some of that. So it's a bit like everything these days, it's a bit up in the air at the moment.
Okay, thank you.
In terms of uploading photographic images to a national database, could you, Police Scotland, outline which images are currently uploaded? And although we don't currently have the body-worn video cameras, when they do come into force, would images from that be uploaded, and if so, which ones?
Okay, so the new the legacy arrangements, if you like, for custody images, where there was, you know, it was disparate, but we now have a new national custody system. So when anyone comes into custody, their image will automatically be uploaded onto the criminal history system, and there will be no retention of any images on databases within our Police Scotland. And then, dependent on the criminal justice outcome, if there's no conviction, then automatically we did. If there is a conviction or there is a procedure thereafter, there's retention arrangements for that and timescales. So the new system is far more robust, if you like, in terms of that retention. And in relation to body-worn video, no, that won't be loaded onto criminal history system or any national system just now. I mean, body-worn video is about recording, obviously, activity by police officers on the front line, and then if that image or those images or that footage becomes evidence, then obviously that will enter the evidence chain. If it's a case of trying to identify people from those images, then we have that capability either physically sending briefings around to officers to say, can you recognise this person? Or it may be that then we have to go through facial recognition retrospectively through the Police National Database, which is obviously an existing capability.
So in terms of the actual image, you've mentioned legacy and custody images, so that's a straightforward front photograph, is it?
Yes.
And with the body-worn cameras? Would that, what kind of image then, photographic?
Well, body-worn cameras is just, it's effectively videoing, activity on the street. So that footage is there to record the, the interaction between police officers and members of the public or whatever. But that then, if that then is required to be reviewed as potential evidence of a crime having taken place or conduct, then clearly it is evidence, a bit like CCTV, if you like. So that is a separate thing from custody images, if you like.
Okay, thank you. Shona.
So there would appear to be broad agreement that the proposal for the Commissioner is a timely one, and you said that yourself earlier on. And I guess you kind of answered this, that the Scottish Government has, you feel, has got the timing right, presumably. What kind of relationship do you envisage having with the Commissioner? You've talked a bit about the public awareness role So the relationship the Commissioner would have with the public is an important one. What about the relationship you would have with the Commissioner as the two bodies? It would be helpful to hear about.
From a forensic services perspective, we hope to have a very strong relationship with the Commissioner. We feel the Commissioner is there to obviously allow us and help us to understand which is the best way forward for databases, for instance, in Scotland. And as I mentioned earlier, there's new technology coming along, which obviously we want to make sure that public debate happens. So I think the Commissioner has a real significant role in that. We'd also like to be involved, obviously, in the development of the Code of Practice. I think there's certainly the draft codes that we've developed. One thing I was so impressed about the IAG, the Independent Advisory Group, was just the representation on that group. We had people there from human rights, with the ICO representation, with universities represented, Sean, myself from Police Scotland and Forensic Services, and also the Crown Office. So there's a good breadth of knowledge and challenge there. And I think that's why the Independent Advisory Group report was so well received, as was the Code of Practice as well. So we would hope that the Commissioner would take the code and take the report and obviously begin to work through that, because there's a lot of really good stuff within that report and the codes of practice as well.
Certainly from a Police Scotland perspective, absolutely welcome it. I mean, the whole legitimacy of what we do and policing by consent is obviously, as you know, based on public confidence. And I think, you know, and we are very much bound by legislation and regulations and operating procedures, and we're used to working there. But, you know, in developing technologies and developing advances in investigation techniques, having that, you know, independent rigour, especially, as I say, you know, an individual that can give us that close working relation. Well, we would have a close working relationship with them, a bit like we do with HMICS, and welcome that input with the ethics panel as well. And then that gives us that platform, I think, to kick on with these advancements in technology that the public would expect us to explore, I think, to keep them even safer. You know, criminal enterprise is getting even more ingenious, I can't quite get the word there, but ingenuity, that's it, ingenuity is everywhere. You know, we want to try and keep pace with that, clearly, to keep people safe. So we would have, I think, a very close working relationship with the Commissioner.
Okay, I'm just wondering, Convener, given we've just been talking about the Code of Practice, if it might be worthwhile just asking what was to be my question later about the whether that should be established in legislation. Obviously, that was the recommendation of the Independent Advisory Group. Do you agree with that?
Certainly, we agree with the codes being established in legislation. However, we felt that the detail of the codes should stay out with that. And that's to give us flexibility, because things are changing so quickly. Right. We want to make sure that the legislation, the codes of practice, are as fleet as foot, and therefore can move on with the times very quickly. And therefore our recommendation was that the codes be established, but that the detail of the codes be worked out, and obviously come back to Parliament then and the public for consultation and then final sign-off.
So the code itself should have a statutory footing, but the detail would be something that presumably potentially could change over time.
It could change over time, and therefore you want to keep that as live as possible. Okay. But it still needs, I believe, the public scrutiny and also coming back to Parliament as well, so these parliamentarians are aware of the code.
Okay. Yeah.
I think it's right that the bill has that requirement on the Commissioner to establish code of practice, but thereafter the details of it, consulting with all there's a lot of named organisations on the bill and others, then that flexibility to do that. And then once the Commissioner's in place, work with all these people, including ourselves, create the code of practice, lay it before Parliament, have that agreed, and then we can move on. And that's a flexible instrument, as Tom said, and we completely agree with that. You don't want to try and have to alter primary legislation if you can have a flexible instrument sitting below it. So, and the technology is, we have potential for gait analysis, vein pattern analysis. There's a whole host of biometrics that could be in the pipeline in the not too distant future. So you want something that's flexible and agile.
Okay, thank you.
John?
Thank you. Good morning, panel. Now, it's been suggested that the Commissioner's responsibility should extend further than Police Scotland and the SPA, for example, to include those who share images with the police service, such as the British Transport Police, local councils, National Crime Agency and private entities. Is that a reasonable suggestion?
I mean, you know, you start somewhere, and as long as that the bill and the code of practice is flexible enough to start to bring others into the mechanism. I mean, British Transport Police just now do use our facilities, so if they have a suspect or an arrestee that they plan to put to court, then they'll use Police Scotland facilities for fingerprints and DNA, the biometrics, and then thereafter they get loaded on from there. There's already that cooperation in that sense. You know, if it's any other organisation, I don't think having the two of us is the prescriptive end of it, but whether it's now, really, I don't really have a strong view either way, Tom.
I think obviously we tried to cover the majority of casework that we would get into Scotland, and that would be done obviously by Police Scotland and ourselves. But we do recognise there may be occasions where British Transport Police maybe would take samples. However, as Sean said, the majority of those times it would be within police custody suites, and therefore would come under our whole DNA and fingerprint regime. But there may be occasions where that isn't the case, so therefore it would be useful to have them involved in that as well. And certainly the Independent Advisory Group recommended that them and maybe even others could adopt the codes in terms of how they practice, and that could be therefore even widen the value that the codes are bringing to the public in Scotland.
That included, Mr Nelson, for instance, the National Crime Agency.
Yes, it could. I'll maybe let Sean speak about
the National Crime Agency. I mean, through cross-border powers, for example, if we go down south to pick up an arrestee in England, then we'll bring them back up under cross-border powers, and we'll take their biometrics in Scotland and load them on, as Thomas previously described. And conversely, if English officers or Welsh officers who came up to Scotland, they have that same ability to do that. So the NCA, they sometimes employ us to help them, and we'll deal with the custodies and the biometrics in Scotland, or there's the cross-border and they go back down south. So it's jurisdictionally it's sound in terms of that agreement. So, yeah.
Previous reference was made to CCTV and local authorities, indeed private enterprises rely on that. Would it not be a frailty in the system if they weren't subject to the same level of controls as you who ultimately receive the information? Would that not be potential for, at the very least, some reputational damage for Police Scotland and the SPA?
Reputational damage for Police Scotland, yeah, if local authorities weren't subjected to it?
Or anyone from whom you are receiving information to, that you're processing the data, images, for instance?
Well, I mean, in terms of evidence capture, I mean, we can get CCTV images from anywhere. Effectively, if somebody has recorded somewhere, there's a private house or a local authority or, any other, if there is potential for evidence, then we'll acquire it and then obviously process it according to the law. So, I'm maybe not quite picking up where you think that might.
Well, there are no challenges you see to the SPA or Police Scotland from the source of where you receive that information. For instance, the concerns there have been about, excuse me, open space, which the public presumes public but is private. There's often been concerns about that, jurisdiction of that.
And are you talking about then, not just simple recording cameras, CCTV, or talking about facial recognition by local authorities?
Well, presumably. Forgive me, presumably you are using your facial recognition techniques on the basis of sometimes CCTV footage.
So we will take an image from CCTV, and if it's a suspect that we can't identify, then you have the facility to upload that image onto the Police National Database for retrospective facial recognition on that database to see if we can get some kind of intelligence that, and quite often when we do that, you might get 5 or 6 or 7 suggestions from that, and with a varying degree of probability, and then you have to then work around that. It's just intelligence. It's not then a facility to go and arrest someone. You have to then think about what other evidence corroboration, and some of the suggestions might be, way left field. But so it is just intelligence. So it doesn't necessarily impinge on anyone's immediate rights in that sense, because we need to work around that intelligence to create corroborative evidence if there is any. If there isn't, then we destroy them.
Okay, thank you.
Jenny.
Just as a follow-up line of questioning to John Finney, the draft legislation as it currently stands suggests that the Commissioner's role should be a part-time position, and this has been the subject of some debate on previous panels, and I'd like to hear your thoughts this morning as to whether or not you would agree that it should be a part-time position.
Well, gosh, I think I'll be busy, so it might need to be full-time, but don't really have a strong view on that, because it depends again on what ultimately the bill decides that that person should do. It will depend as well as probably on how much support staff they have at their disposal as well. I think it will be an extremely busy role, because this is a burgeoning area of business, and there is so much to do. And I think it's probably been touched on previously that I think some of the issues are more about private databases and what happens out with the police and the SPA, because we're very, heavily regulated and legislated for, and pretty good at what we do in that sense. But there is so much out there that is sitting in private databases and private companies and other areas that that's the area that's unregulated and ungoverned, and so extending that code of practice into other areas will be a huge task, I think, and therefore might suggest that full-time might be the best option. But Tom, you got any?
I know obviously in relation to England and Wales, obviously they have a biometrics commissioner, Paul Wiles, and he covers the 43 forces down south and all the forensic practitioners down there as well. So I think 0.6 is probably reasonable, but a lot depends on the number of staff that person would have in terms of supporting them. I think early on, in the early days, there may need to be a requirement to have it maybe more full-time to get the ball rolling and get things in place and to begin that public engagement, public debate. But certainly I think probably 0.6 is a reasonable amount of time given the size of Scotland compared to obviously England and Wales.
Thank you.
Just following on from the fact it's a part-time position, the Commissioner's general function, do you think that carries enough weight, given this is to support, promote lawful and effective and ethical practices in relation not just to the acquisition, but also the retention and destruction of biometric data?
So do we think...
Do you think that general function carries enough weight? And perhaps when you're answering that, you could perhaps tell the committee a little bit more about the retention, how long it's data retained and for which particular crimes, and also just provide some assurance about the immediate destruction of any data that is no longer required.
Sorry, do you want to just give the first bit out again? Apologies.
Yeah, there's a lot there. General function, does it carry enough weight? Because a lot there about lawful, effective retention, destruction.
Yeah. I think in terms of the general process, that is correct. I think it is. Certainly, I know there's some discussion previously about should there be any enforcement of penalties or things like that there. I think in the policing world, actually naming and shaming is probably the worst thing you could do. So I think there's a lot of strength in taking that approach. And certainly Paul Wiles mentioned that in his evidence, that obviously whenever he does that, police forces and others do respond. So certainly there's a lot of regulation around all that we do. So for instance, within forensic services, we are accredited to United Kingdom Accreditation Service, UCAS 17025. So we have our business covered by that assessment organisation, and they would come into our organisation and spend between 60 and 70 days a year just going through all our processes and all our practices, and effectively they give me the licence to operate, because obviously if they don't sign off the work that we do, then we say can't load samples onto the National DNA Database, for instance. So there's quite a lot of assessment and review that goes on from UCAS, United Kingdom Accreditation Service, but also from other bodies like HMICS as well. So there's quite a lot of assessment and review of just our practices and processes.
But that sort of view, would that be fair to say that's reactive rather than proactive? And maybe if the Commissioner's general function had more weight in terms of maybe more enforcement powers, it might be more proactive?
I think if the Commissioner come up with recommendations that we should be doing something, we would adopt those recommendations.
I think though that the point you make is well made. I mean, promote and monitor the impact of the code of practice, which is the general principles and how the police and SP will act, and really we know that these new technologies are coming in, and I think that's implicit in there that you know, we're working closely with the Commissioner to be proactive about, you know, what is coming up, what's now potentially a valuable tool in keeping the public safe. So we would be working closely with the Commissioner and the Ethics Panel to do that. And I think that's implicit in there. Whether proactivity as a word needs to be included, then, you know, that, you know, greater minds than mine might feel that needs to be, but I think it's implicit there. And it's a bit like we do with HMICS. You know, we work with them to say, well, where can we improve areas of business and work with them to do that. I think that's the case here. I mean, in terms of as well the retention of biometric data, you know, part of the one of the 9 recommendations of the IEG was about retention and the periods of retention, and there's a presumption of deletion, which is absolutely right. You know, so I think the choreography of all the recommendations of the IEG, which the government accepted as being, you know, legitimate, is start with the Commissioner and a code of practice, and then start to develop these other recommendations and work on them. And as I say, we're already proactively doing some work around some of the recommendations within Police Scotland, not waiting for any legislation, because it's the right thing to do around, you know, people's awareness of their rights and the, you know, proportionality, whether we take biometric data from children or not, at the age of 12 to 17. We're implementing a process where we're considering a case by case. Just because we can take it, it's not necessarily the right thing to do. So there's that proportionality that we're implementing as well. So I think the Commissioner, based on what's here, will be proactive in the role. But again, as I say, it might be others that feel it needs to be more implicit in there. But
before I bring James in, could you just put on record what the retention policy is? I know for certain offences it's 3 years retention. For others, it's immediate deletion.
It's quite a bit of a mixed bag. I mean, you know, there's certainly I can provide a written sort of chart, if you like, of all the retention times, and depending on you know, whether it's fingerprints, photograph, DNA, you know, we have that. So I can provide that to the committee if you like.
But certain offences, would it be sexual offences? Then it would be maybe. Or violent, there's a 3-year retention for certain?
Yeah, there's a 3-year for that just now, and the Chief Constable has the ability to apply for an extension of 2 years for that if required, so that is already in legislation. But there are obviously other retention periods based on other levels of criminality. And
would it end at 5 years, or would that extension be repeated time and time again?
There's no limit to how many 2 years you can apply for, but it doesn't happen. Hasn't happened, so we haven't had to do that. But it's a power that is there if there's an exceptional circumstance where we want to do that.
Yeah, and in terms of reassuring the public, if it's data from individual arrested for any offence who haven't committed an offence previously, it's destroyed immediately after if they're not convicted.
Yeah.
And oversight on that. Okay, James.
Okay, thanks a lot, Convener. Mr Nelson, in a previous answer to Shona Robson, when we were discussing the Code of Practice, you said that you'd done some work around a draft Code of Practice, which I think is very helpful. Can you maybe outline what are the main factors in that draft that you would see being encompassed in the Code of Practice in this legislation, which are important to ensure that the Code of Practice is robust?
Sure, it is quite a lengthy document. It's about 20 pages long, but in relation to the content, it obviously defines what biometric is, what biometric data is. It goes through the purpose of the Code of Practice, and then obviously looks at the human rights aspect of the retention and how we should be obviously looking and reviewing that. And it goes through some general principles, and one of those principles is around about introducing new technology, and obviously the process that we should follow with introducing that new technology or new evidence type into, say, for instance, forensic services. So that would follow very much. I sit on the Forensic Science Advisory Council. So in England and Wales, they have a forensic science regulator, Dr. Jill Tully. I sit on her advisory council, and the advisory council, along with Dr. Tully, generated guidelines on how new technologies could be validated to show that they're actually fit for purpose, and the instrument that you're using is actually giving you the expected result from that instrument. So there's a whole process built around that, and that is also included in the Code of Practice as well. And then also where people can get information in relation to the data and how that data has been used and how successful or not that data has been. So the Code of Practice covers all of that. And as I say, it went out for consultation almost about 12 months ago. And certainly was a very positively received document. There were some recommendations, but it is still sitting in draft form.
Okay, that's helpful, particularly the comments around new technology, because obviously that's an area that, as it evolves, it's important the Code of Practice is able to deal with changes in technology. Just in relation to that, do you think that the Code of Practice needs separate sections for different technologies?
I think in terms of most technology will probably follow the same principles. So I think providing we get the validation principles correct, I think that could be applied to any technology. So for instance, before we would bring in a new technique within forensic science, obviously we've just brought in the new equipment for the drug driving legislation. So we had to spend almost a year being prepared for that, getting the instrumentation, ensuring the instrumentation is giving us a desired result, making sure that not only is the people who are supplying the equipment telling us it's going to give us these results, but then actually putting the equipment into the environment that's going to work with the different gases, etc., to make sure that that produces the desired result every time. And that's part of the validation process. That would then, in forensic science, that then goes through, obviously, for accreditation. And that's whenever we ask the United Kingdom Accreditation Service to come in, and then they would go through all the work that we have done, and they would effectively then give us the validation stamp that has been accredited.
Okay, thank you.
As the bill stands at the moment, Police Scotland and the SPPA, I quote here, must have regard to the Code of Practice, and failure to do so doesn't itself give rise to grounds for legal action. Do you have a view on that approach? Much has been said throughout this session about public confidence. Do you think there's a contradiction there if it's just have regard to rather than there be any legal sanctions for failure to have in regard to?
Well, certainly from our perspective, I mean, it's a bit like how we work with HMICS. I mean, we work with recommendations, and we generally, work on those recommendations to implement them. If there's any area where perhaps that we have an opposing view, we have discussions about that, and then we come up with some kind of resolution. So really, in terms of the work we would do with a commissioner, then in terms, I don't think we would ever get to the point where that we would refuse to comply with if there was a recommendation or a direction to travel that we had issue with, we would have that dialogue with the Commissioner way in advance of getting to that stage. I'd like to think we'd be able to work it through. So I think you probably feel the same, Tom. No?
Certainly as Director of Forensic Services, if the Commissioner come up with a proposal that we should follow, I'd be very hard not to follow that, and certainly my board would be wanting and holding me to account of why we didn't follow that.
So you don't see this as a frailty, because you used the term there, opposing view, Mr. Scott.
If we had an opposing view,
yeah.
No, opposing view in the sense of that we would do work with the Commissioner, so probably getting to the point where recommendations are made. We'll have worked closely with the Commissioner and the Ethics Panel to get to a point where the recommendations are where they are, and then we would implement them. So it's highly unlikely that we'd ever get to an impasse about something, but that's...
So just for clarification then, would either of you have any concern if the bill was amended to ensure that there was a requirement to comply rather than just have regard to?
If that was the feeling of, obviously, Parliament, obviously, that would be the way to go. But certainly from my own perspective, I know I couldn't stand before my board and answer why I wouldn't have followed something that came from the Commissioner as a recommendation. And I personally would be
more comfortable running that past our legal services, if you like, in terms of that terminology about that, I think. So I'll reserve judgment on that one.
Okay, thank you very much. Okay.
Fulton.
Good morning, panel. You've both talked a wee bit about the biometric technologies are evolving at a rate of knots. I think we can accept that, and the particular issues that can come out of that. Do you think that this bill's a reasonable attempt to keep up with developments in this area, and do you think that the Code of practice will be enough going forward to be able to adapt to new issues and technologies as they arise?
Tom mentioned about the general principles that are included in the Code of Practice, but within that Code of Practice or the draft, there is also how the general principles are implemented. So there's a clear kind of direction there about how we implement, and there in the implementation and how we process data, there are directions in there that help us in terms of the consideration. So I think between the principles themselves, how it's implemented, and then the considerations we need to have regarding the collection and processing of data is sufficiently broad and wide enough to cover any eventuality in terms of how biometric data and advances in technology will bear out in the future. So pretty comfortable with that. That's a starter for 10, very much so. And clearly then that would be refined through the work of the Commissioner and others to get to that final product. But I think it definitely helps in terms of not just where they are, how we implement, and the considerations for processing and retention. So I think it's sufficiently broad.
I think in relation to obviously the work that the Independent Advice Group did coming up with the codes, there's a lot of work obviously went into drafting these codes, and obviously there's a lot of people involved from both the human rights, the practitioners, the academics, Crown Office, etc. So a lot of thought went into developing the codes. So I think the codes are very much fit for purpose, and certainly they do address some of the new technologies that are coming in. And I know obviously Mr. Wiles was concerned that he hasn't got that control in England and Wales over new technologies. Certainly this does give us that control over new technologies coming in. So I do really believe it is definitely fit for a purpose. That doesn't mean it won't evolve and won't change, and therefore that's why the Commissioner needs to obviously, when he or she would start with the codes, obviously potentially go out for another phase of consultation and then taking the codes through Parliament to getting signed off, and thereafter there will be some process to review the codes on a regular basis.
But you are satisfied that the codes are flexible enough that it wouldn't require further legislation as far as you can envisage at this stage?
That's correct.
Yeah, I think the fact that it's included in the code as well is about the validation and the reliability of these new techniques is explicitly covered, and Tom mentioned that, validation and the fit for purposeness, if you like, of the technologies is a key part of it, and that's all covered in there as well. So whatever it might be in the future, we have to bear mind about validation and that the reliability of the technology.
Okay, thanks. I wanted to ask as well about that you've both made the case that it should be the Forensic Services Department of the SPA which will be subject to the Code of Practice and not the SPA, and you've asked for the bill to be amended in that respect. Just wondering if you can elaborate a wee bit further on that and your thinking behind that specifically, that request for an amendment. Tom?
So whenever I obviously read the document itself, it does mention the Scottish Police Authority. Now obviously the Scottish Police Authority is a legal entity. But obviously, I thought it just could be more prescriptive in that the Scottish Police Authority could mean many things to different people, including the public. And obviously, Forensic Services, as far as the work and the delivery of that service, that's all done within SPA Forensic Services, and therefore I thought it might be worthwhile just drawing that out, because obviously it is drawn out under the constables and obviously this police staff who work for Police Scotland, so I thought that was the only reason I mentioned it.
Okay, thanks very much. One more question, Convener, if that's okay.
Yep.
Obviously, the Scottish Commissioner will only be working with one police force rather than the situation in England and Wales, where they're obviously dealing with multiple forces. Do you see any benefits or alternatively disadvantages to that going forward?
I think it's an advantage in that obviously instead of things being done 43 times differently, potentially, obviously there's one way of operating with a single force, and therefore you've only got one group of people to engage with. So I think actually it would probably make the role of the Commissioner easier in that regard.
Okay. Agree with that. Okay, that's Convener.
If I could just return very briefly to this this question about who should be subject to the Code of Practice. When I asked you about who currently has regard to the governance of the process involved in collecting and using Betromad, in effect, who is oversight over these processes with regard to Police Scotland and the SPA, you said that the SPA had overall governance. That being the case, then, wouldn't it seem reasonable that the SPA as an entity should also be subject to the Code of Practice?
Totally, yes. I wasn't asking for them to be taken out, but also just forensic services to be added to that.
Right, so they would be, as a legal entity, SPA as a whole, on that function, and forensic services to be added to it. That's very helpful, thank you.
It's more about the fact that, you know, for police it's explicit about constables and police staff, and wasn't quite so explicit for the Scottish Police Authority, and I think that that was, you know, why we backed that submission up as well. So.
Thank you. Liam.
Good morning. There are obviously a lot of ethical issues coming through here, and the bill as it's currently drafted doesn't provide for an ethics advisory group, but what we know is that the Cabinet Secretary's intention is to establish one such group. Do you have any view on the merits of establishing an ethics advisory group, and if broadly in favour, do you have any thoughts on who might be on it and how it might go about helping the Commissioner?
Well, we're very supportive of that. You know, everything that we do in Police Scotland now in terms of new processes and how we want to do our business is underpinned by human rights and quality and the appropriate impact assessments, and you know, especially in an area as sensitive as this. I think traditionally, when police have been looking to implement new ways of working, I'm not saying it's been done in isolation, but there's been opportunities in the past that probably could have been better enhanced or processes enhanced by a wider ethical and engagement further, because it's not just about the police, it's about the whole of the public. So we welcome that opportunity potentially to work with an ethics panel to explore these areas particularly, and I think we would be neglecting us if we didn't have that wider consultation and that input. And as Tom mentioned earlier, the IAG, its construction was very much about that, with you know, explicit human rights representation, information commissioner, academics, and I think it worked really well. And I think the recommendations that came out of that are balanced and effectively, I think, show the benefit of that wider engagement, and we would wholeheartedly embrace that. I think it's necessary.
Thank you.
Certainly, I sit on quite a few bodies down south in England and Wales. I've already mentioned the Forensic Science Regulator and her Advisory Council. I also sit on the Home Office Biometrics Strategy Board, and as part of that, there's also the Forensic Information Databases Board, and basically the ethics group of England and Wales report into that group. And certainly in England and Wales, there's a very strong need, I believe, for us all to have an ethics group, and therefore I think we'd be replicating something similar to what was in place in England and Wales. And I know the value that does bring to particularly DNA and some of the advances that we know are potentially coming down the line. Having that ethics discussion by the right people around the table, I think, is essential as we move forward. And I think that person should obviously, it's probably, I would have thought, something that the Commissioner would certainly want to be bringing in fairly soon.
Thank you for that. Just moving it forward very slightly, the bill as currently drafted doesn't provide an opportunity for members of the public to raise concerns about the Commissioner. For example, I don't think there's an individual complaints process that the public could avail themselves of. So do you take a view on whether the bill might be amended to provide such a process, or perhaps your view might be it's unnecessary?
I mean, the public obviously can complain, have a right to complain about anything like to Parliament, on any subject, and it would be addressed. And I'm not entirely sure whether the lack of any particular specific public complaint mechanism would then remove any effective means of dealing with a complaint. If a complaint came in, and then clearly it would be dealt with. But I'm not sure whether the bill would necessarily need that to be explicit in that regard, Tom.
I think it depends obviously what the complaint's about. So obviously the ICO has a role obviously to play in relation to complaints of their information, and therefore that would be a route in potentially for people to complain. However, I would have thought the Commissioner would want to be hearing the public and understand where their concerns are coming from, and certainly that ability to go out and to speak to the public and engage with the public, which is obviously the #1 recommendation from the IAG, I think would allow the public and the Commissioner to understand obviously where we are in relation to public assurance, but also identify if there are any challenges or issues out there.
Thank you.
I think that question is really targeted at public confidence, not just awareness, it's confidence. And I think we all agree that if you've got a clear way to be able to complain, and that's advertised, then I think that increases public confidence. John.
Thank you, Convener. Panel, I want to return again to the issue of public confidence and awareness. Now, there's a suggestion, a role for the Commissioner, and perhaps you would have some views how he would promote public awareness and understanding. But particularly with regard to the repeated comments from both of you about public awareness, and Mr Nelson, you talked about critical public awareness with this. You will be aware that there's suspicion about police activity. That's an inherent part of any liberal democracy. People question people having powers. So the purpose, indeed the intent of this legislation and the potential for any sort of unintended consequences, collateral intrusion, call it what you will. I wonder if you could tell the panel, tell the committee, sorry, how Police Scotland and the SP currently engage with the public to provide reassurance. And with regard to a very specific issue, whether lessons have been learned about the dearth of that in relation to cyber kiosks, which the public will view in a very similar vein to this issue.
Well, if I pick up correctly what you mean, I mean the cyber kiosks as separate from this in terms of a subject, I would suggest, and you know, it's well rehearsed what's going on with cyber kiosks, and I don't have any involvement in that particular area of business. But in terms of,
well, just if I may interrupt you, then sorry, Chief Superintendent Scott. It is about the public confidence. It is about the police engagement, and I wonder if there's the potential for lessons to have been learned from the failure to do that in that.
Oh, sorry, right. Well, I mean, there's lessons to be learned anyway. And of course, if there are lessons to be learned, and as I say, I'm not explicitly involved in that side, but yet, so any lessons in terms of public engagement, we always try and take on board in terms of our corporate communication and our local communication as well. So clearly we would. I don't know specifically what those lessons are in terms of cyber kiosks myself, because I haven't been involved in that area of business, but I know that there obviously there have been issues with that implementation. But that wider public engagement around biometrics, as I say, we're starting off with the notice that we will do for anyone that has their biometrics taken from them, so that awareness about what happens to that, as I explained earlier on, and then clearly any work that we would do around biometrics in conjunction with a commissioner would be part of a wider communication strategy for the general public, and we would look to make sure it's explicit about our intentions and how we're going to work, and you know, if there are areas that public need more information on, then we'll provide that.
I think from a forensic services perspective, we don't do enough communication. I think we do an awful lot more. Obviously, we do on the website have data in relation to our DNA and obviously all the information about the samples and the hits, and it also explains a bit more about what DNA is. So there's quite a lot of work has gone into developing that. But I think that needs to go wider. And certainly we look for the opportunity to work with the Commissioner to see how we can do more within forensic services to increase that awareness of the public, because it is crucial. The problem is if you lose that public confidence, then you lose everything.
I'm sure all the members of the committee want the police service to be given all the tools to protect the community, but with legislation, it's important that we have robust legislation that's thoroughly scrutinised. If I maybe turn to the issue of live facial recognition technology, concerns have been raised about that, about the use of some biometric technologies, in particular live facial recognition. And the specific concerns have included privacy and human rights issues, the accuracy of the technology, and the potential for bias. How valid are these concerns?
Well, I mean, they are valid because I think they've been borne out, and we are acutely aware that that any progress in terms of live facial recognition technology needs to be appropriately considered. As I think we're about to provide you with a fairly detailed response, I think, because clearly there's been a separate request for written evidence around facial recognition to Police Scotland, and I know that's currently in the pipeline. I'll be with you shortly. As I say, we at the moment have not been involved in any kind of live testing or involvement in live facial recognition technology, but we appreciate from certainly through the media and other police force use of it, there are issues with the technology, the algorithms that are used, and we need to get that absolutely right before we would do anything in Police Scotland. So we'll go through the necessary mechanisms, governance and ethical considerations before there was any move towards that. I think you know, it's right though, as you alluded to, Mr Finney, that the public expect us to use the best type of technology to keep them safe, and it's clearly an area we want to explore, but it will be done with the appropriate measures and regulations.
I think so. We're looking at what has happened down south, and I think there's some lessons learned there for ourselves to take on board. So I think we need to understand and test the system, as Sean has said, before we would actually even look at that within Scotland. So there's a whole bit of work that needs to go around the validation of that facial recognition technology, and also the algorithms that lie behind it, and that can be done, that can be tested by developing what's called a ground truth database, which is effectively a database of known results, and then you can test your system against that, and that's one way to begin to understand how confident you can be in the system, but also allows you to understand the limitations of the system as well.
Okay, thank you very much.
That concludes our questioning. Can I thank both witnesses for attending, and can I also ask if there are any questions that come up in the course of us scrutinising the bill that we could write to you and perhaps get some further answers. But for now, thank you very much for a very worthwhile session.
Thank you very much.
I suspend briefly to allow for a change of witnesses and a 5-minute comfort break. Agenda item 3 is consideration of 2 affirmative instruments, the Victim Surcharge Scotland Regulations 2019 draft and the Victims and Witnesses Scotland Supplementary Provision Order 2019 draft. And I welcome Humza Yousaf, Cabinet Secretary for Justice, and his officials, Zach Tuck, Victims and Witness Team Leader, Pam Scott, Victim and Witnesses Policy Advisor, and Craig McGuffey, Director of Legal Services, the Scottish Government. I refer members to paper 3, which is a note by the clerk, and paper 4, which is a private paper, and invite the Cabinet Secretary to make a short opening statement.
Thank you, Convener. Thank you for inviting me to give evidence in support of the affirmative instruments needed to introduce the Victim Surcharge and the Victim Surcharge Fund. Firstly, I want to start by acknowledging that it has taken longer than anticipated to lay these instruments. The time taken was necessary to ensure the scheme is administratively efficient, legally competent and enforceable, and importantly will provide help to victims of crime at the point of need. Work undertaken to get us to this point included seeking an order under the Scotland Act 1998 to enable recovery of the surcharge through a deduction from an offender's benefits. This order came into force in July this year, enabling us to lay these regulations now. We also had to address an issue whereby the surcharge could have potentially be interpreted as a fine. If we left this unresolved, it could have resulted in the imposition of the surcharge being challenged, for example, where there are maximum fines in place for specific offences. We're committed to putting victims very much at the heart of our justice system and making sure their voices are heard. Building on the positive measures introduced through the Victims and Witnesses Scotland Act 2014, we have delivered a range of initiatives to support victims and witnesses. For example, we introduced the Vulnerable Witnesses Criminal Evidence Scotland Act 2019, which ensures more child witnesses are able to pre-record evidence ahead of jury trials. We've also set up a dedicated task force, as the committee know, to listen to victims' experiences. I'm investing in a new service to provide dedicated support for families that are bereaved by crime. We've invested over £155 million over the last 5 years to improve support for victims and their families and to provide compensation to victims who've sustained criminal injury in Scotland. This includes funding for Victim Support Scotland's Victims Fund, which provides very practical support to victims in the aftermath of a crime. In terms of the victim surcharge, we know that experiencing crime can be an isolating and frightening experience. It's only right that criminals should pay towards helping victims to recover and move on with their lives. These instruments will enable this to happen. The victim surcharge will be imposed on individuals who are sentenced to pay a court fine. The amount of surcharge imposed will be proportionate to the value of the fine. The surcharge will be collected by the courts in the same way they collect fines and compensation orders and transferred to the Scottish Government to be banked in the Victim Surcharge Fund. As set out in the regulations, no awards will be made from the fund until after 25th of May 2020. This is to allow time for money to accumulate. Victim support organisations will be able to apply to government for a share of the fund to cover the costs of providing short-term and practical support such as new windows, locks for victims of housebreaking, or indeed funeral expenses for families of murder victims. This model, whereby government administers the fund, will ensure that victim support organisations can focus on doing what they do best, supporting victims of crime in communities across Scotland. This model also ensures that victims can access quick support at the point of need from those best placed to help them. In terms of likely income from the surcharge, we estimate around £100,000 could be collected within the first 12 months of the surcharge being in operation. This could potentially reach a steady state of around £800,000 per year after 4 to 5 years of operation. The regulations also state that we will prepare and publish guidance for applicants on the operation of the fund. This will cover topics such as assessment criteria for awards and what the fund can and cannot be used for. This has been shared with victims' organisations to seek their feedback and ensure the application and award process is as efficient and effective as possible. This engagement will continue as we move towards finalising the document, which will be published no later than May next year. To conclude, the support that we provided through the Victim Surcharge Fund will mean victims and their families have one less thing to worry about at what is already a very traumatic time. In supporting these regulations, the committee will ensure the money raised through the surcharge can make a real difference to victims and their families. And as always, I'm happy to take questions.
And we move to questions now, starting with Liam Kerr.
Thanks, Convener. Good morning. Cabinet Secretary, are you able to tell us the thinking about restricting the surcharge to those paying a court fine? I think in your introduction, what I heard was it might be to do with the surcharge not being an extra penalty, but perhaps if you could elaborate on that. And also the way in which the surcharge is calculated, the method behind it.
Yeah, thanks for the question. So I suppose the first thing to say in all of this is we'll continue to keep things under review. So it's important that if we, in years after the surcharge is not just come into force, but is actually distributing money, if there are potential ways to improve that, to strengthen that, to potentially widen and expand that, then we should be open-minded, and we will be open-minded. So I think the first thing to say, we'll always keep that surcharge under review, and that's important. Secondly, the reason why it's attached to those that receive a court fine, and it should be, there's no discretion in that. So if you receive a court fine, the victim surcharge comes on top of that, is that the courts already have a process and mechanism in place to collect court fines, and they're very good at it. 88% of fines are collected, part collected. So they're good at that, and they have a mechanism in place. So imposing an additional surcharge on that shouldn't be hugely cumbersome, and the process and mechanisms allow that to happen, whereby if, for example, they were not related to offences that carry a court fine, the collection of that money would involve a whole new process, which could involve further delay, etc. And I'm not saying that we shouldn't, again, I'll reiterate the point that we should be open to any suggestions that come forward. This was also on this, what we've done in terms of aligning this to court fines also carries support in the consultation as well. In terms, I think the second part of his question, if I understood it correctly, was the amount that's payable in terms of proportionate value of the fine. So we have in the draft guidance what the surcharge, how much the surcharge would be that is proportionate to the fine that is there. I think it's that's been done on the back of the consultation that we had. I was discussing this with my officials before I came in here. I mentioned in my opening statement that we've shared the draft guidance with victims' organisations and so on. I see no harm in sharing it to the committee as well if they're interested in looking at the draft guidance and obviously giving us their thoughts too. But yeah, the surcharge is proportionate to the value of the fine. I don't know if any of my officials want to add anything in addition to the reasons why we talk about the proportionality of the surcharge, but is there any other issues that are related to the level of the surcharge compared to the original fine?
Part of the reason for going down the proportionate route was we used the standard fine scale in Scotland, and so we were able to map the surcharge onto that, which ensures that it's proportionate. And also, committee might have noticed that once you go above the statutory maximum fine, it then changes to a percentage of that total fine rather than an amount, just to make sure that when you're at that high level of fine that you maintain that proportionate approach.
Oh. Thanks for that. So, taking that to the logical next step, you say, Cabinet Secretary, 88% of fines are collected, and we talk about it being proportionate. So, how do you envisage the courts dealing with the ability of a person to pay a financial penalty once the surcharge is introduced? Because obviously that could impact the 88%, for example.
It shouldn't do. I mean, part of the reason why we've aligned it to court fines is because of that reason. So the courts are good at, obviously we want that figure to be even higher, of course we do. And there's some work actually ongoing in and around that. But, you know, the courts have a mechanism in place. This won't add an extra burden to them, or not a significant burden on them to collect those court fines. Of course, part of the order that we required from the UK government will also hopefully help with that, because it means fines and the surcharge can be collected directly from benefits as well, which is hugely important. So that Section 104 order means that we can make a deduction from offenders' social security benefits as well. So that existed for the victim surcharge in England and Wales, but didn't extend to the new victim surcharge in Scotland. So the new order from the Westminster government allows us to do that. So I don't see it placing an undue burden on the courts and I expect the collection rates to, well, not just remain steady, but I hope that they increase. Thank you. Yep.
Cabinet Secretary, I think in your opening statement you said that the Scottish Government would administer this rather than any victim support organisation to allow them to do what they do best. Could you perhaps outline in more detail what would be involved in the Scottish Government's administration?
Well, as I say, I reiterate, it just allows organisations to get on with doing the victim support element of their work. And we often, when we think about victim support, we think about national organisations like Victim Support Scotland, and I don't doubt, of course, they'll have an interest in the fund. But there may be a number of smaller organisations that just do not have, excuse me, a huge amount of resource that they can divert to the administration of a fund. So our Victim Support Scotland is a relatively large organisation, or much smaller organisations, particularly in perhaps more rural geographies and locations, to get them to divert resource to administration of a fund, I think wouldn't be the best use of resource. So that's why the Scottish Government will step in. Also, I suppose to answer your question a bit more directly, it would also allow the Scottish Government oversight of the fund. We'd obviously have a number of funds through a number of government portfolios that we disburse. So we have that robust application process. Yes.
You're answering the question that's here on my printed sheet, not the question I asked you. I asked, could you outline exactly what would be involved in the Scottish Government administering the fund?
Well, we would essentially...
There's obviously a cost, and that cost could be broken down into the component parts, perhaps.
Yes, I mean, for those organisations that are applying for the fund, up to 5% of their application can be for what costs might come to them for their part of administration of the fund. From our perspective, I'll look at whether or not I have exact detail in the BRIA, which I'm sure would be there in terms of what the cost might be to the Scottish Government. But we don't, I don't see it as being overburdensome to us to administrate this fund. And what's involved in that would then mean, of course, the victims' organisations can apply. Here I have some of the costs involved, which is in the BRIA. In terms of the Scottish Government, there'd be a cost associated with the fulfilling of the role of operator of the Victim Surcharge Fund. Recurring costs we estimate will be approximately 26,000 per annum and will be recouped from the victim surcharge as an outlay occurred in administration in terms of Section 253G of the 1995 Act. There'd also be an estimated cost to the Scottish Courts and Tribunal Service as well, some non-recurring costs and also some recurring annual costs as well. But that's all laid out in the BRIA.
Yes, and just turning to the BRIA then, it would require staff time to account for the funds received from the SCD, processing of applications from VSO, for payment from the VS, record keeping, oversight and reporting. Who physically will be doing this in the Scottish Government?
I don't think I could give you a name, but perhaps look.
I was wondering, would there be ministerial input or would there be purely regulated by the civil service?
I mean, ministers, and I'll want Zach to come in a second, but I mean, ministers, when it comes to funds, being the kind of guardians of public money, we'll often, of course, give our sign-off to applications eventually, but they'll go through a rigorous process before then. So, yeah, ministers will of course, sign them off the final stage, but I'm happy for Zach to come in with a bit more perhaps detail.
Yeah, so in terms of administering the fund, it will be my team, so the Victims and Witnesses Policy team within the Criminal Justice Division in Scottish Government. So we will open the fund up to applications from victim support organisations, and then they'll have to fill in an application form, which we will then take and we will assess, as we do with currently funding with applications for grant funding. So there's several criteria they'll need to meet. They'll need to be able to demonstrate that they've got a track record of supporting victims of crime and the usual due diligence and finance checks. If they satisfy that process, and we would then move to recommend them to give them a share of the Victim Surcharge Fund, which they can then use as they see fit to support victims. And at that stage, what would tend to happen is once we've done our official assessment, a paper would then go up to the Cabinet Secretary outlining our recommendations on how we disperse the funding. That process will all be open and transparent and in the guidance which will be shared by the end of May.
Obviously, the Scottish Courts Tribunal will have a key role to play, and that will involve the Scottish Government too, with liaising with them. They've said that the set-up costs would include case management systems and progress is being made with that. Can you update the committee on what progress, and is that reliant on IT technology being improved and replaced?
Well, we don't have anyone from the court service here today, but my understanding of that is they need to make some changes to their database and their fine collection processes, because at the moment they don't collect the surcharge, so they need to put a new process in place to enable them to do that. They've estimated that set-up cost will be a one-off. I think it's £22,000. And in the submission they've put forward for the committee, they've confirmed that they'll be ready to have that in place for the 25th of November, which is the coming into force date. They've also flagged up recurring costs, which they've estimated is the additional time it will take the courts to actually impose a surcharge on people, and they've estimated that as a minute per case, which works out about £135,000 per annum. That funding won't come from the Victim Surcharge Fund. We'll be looking for a separate income stream for that to cover the costs for the courts.
Yeah, as you mentioned, there wasn't anyone there from the SCTS, but obviously as part of the administration, staff time will be required to receive these funds from SCTS, and if there was any hitch, then obviously you would be keen, I would imagine, to make sure that the case management system was progressing, even at this stage, to have some indication of that, given we're talking about rollout in November, which is a short, beginning this collection in November. So I think it would be helpful if you can, in perhaps other evidence, provide an update of exactly where we are with that, because it does seem quite key to the whole process. And just finally, before I move on, will VSS and other people be able to keep a surplus if they haven't used it, and use it as and when? That's something that they were keen to establish.
I haven't looked at the issue in great detail, and I need to look at whether or not, accounting-wise, etc., that could be done, or whether the funds would have to come back into the general pot and they could reapply again. But certainly, for me, because the money is there for a set purpose, if it can be kept by the victims' organisations for that purpose, then I'd be happy to explore that. But I do have to say to the committee that I need to go back and speak to finance officials about making sure that the various regulations that we have, particularly for transparency's sake, if nothing else, that would align with that. But I don't know again if officials have any particular view.
Well, they were keen to know if they could bank these and then use as and when, so that would be very helpful. Thank you. James.
Thank you, Convener. Morning, Cabinet Secretary and officials. You said in your opening statement that the support of victims should be at the heart of the justice system, which is absolutely correct. Can you explain then why provisions to allow victims to apply directly to the fund haven't been taken forward?
The proposals we've set out will be a much quicker way and frankly an easier way for victims to apply for a fund, as opposed to the government then disbursing the fund directly to victims. So I respect why James Kelly asked the question. I think there's a legitimate argument to be made for the view that he expresses, but I do think it would take longer for victims of crime potentially, whereas what we're suggesting is pot of money going to an organisation like VSS, who work with victims on a day in and day out basis, know their circumstances really well, and are able to make a really quick decision and a quick turnaround, potentially within 48 hours, for example, and get money into the victims as well. More so pay off an invoice for fix broken locks, or be it, for funeral expenses or anything else within a really quick time frame. Whereas if government had to do that, so we don't have necessarily a direct relationship with all the victims, of course, of crime. Therefore, there'd have to be a real rigorous kind of due diligence that we would have to do centrally. I think it would add time And I think that wouldn't be good for victims. So while I respect the reasons why James Kelly asked the question, I think it's legitimate, I do think this approach will see victims benefit in a much quicker timescale.
So just to be clear, if a victim wants to make an application, do they make the application to the victim support organisation, or does the victim support organisation make the application to the fund on their behalf?
No, so twice a year the fund will be open for victim support organisations to make a bid. When they have that fund and the application has been granted, the victims would go to the victim support organisations who would have a pot of money sitting there, which again would be open. Our thinking is at this moment, obviously it's a draft guidance, but our thought would be that would open twice a year. But again, let's keep that under review. So the organisations would have a pot of money, and victim support organisations would, victims would go to those victim support organisations.
So if a victim support organisation's got a pot of money and a victim then makes an application, it's signed off by the victim support organisation in terms of authorising the money to go to them?
Yes, that would be correct.
And what would be examples of, you know, victim support organisations that would be able to apply and administer these pots of funds?
We're trying to make it as wide as we possibly can. At the same time, obviously, we have to have fairly due diligence, again, as you would expect us to do. This will be in the draft guidance. Again, I'll share it through the convener to the rest of committee. But there would be things, for example, we'd want the organisation to have a track record of providing services to or indeed treatment that's intended to benefit the physical or mental well-being of victims of crime for at least kind of 2-year period. We also obviously want to look at the organisation's aims and objectives, that they have a clear focus on providing support for victims of crime. But we're trying, and of course, looking at things like asking questions around the approximate number of victims they might help, the geographical area they cover, etc., etc. What that shouldn't be confused, because we're trying to make this as open as possible, is that it's organisations that are purely set up for victim support. So I'll give you an example. There are a number of racial equality councils across the country. They'll do a plethora of work. They'll do lots of work across a range of issues. And some of their work might be supporting victims of crime from an ethnic minority background that normally wouldn't go to other services. So, you know, they're not set up specifically for that work, but they've got a proven track record of helping victims of crime, in this case, and ethnic minorities, but you can see the same in many other organisations for other protected characteristics. So we're trying to make it as wide as we possibly can, while at the same time ensuring that there's the obvious due diligence that you'd expect the government to do.
Okay.
Jenny.
And just to kind of flip James Kelly's question round, would there be any examples, Cabinet Secretary, of organisations that might not qualify for the fund? And I don't know if you can give examples today. So, for example, would miscarriages of justice, that organisation, would they perhaps not qualify for it, or are you not able to provide that detail at this time?
We wouldn't want to prejudge obvious applications. I suppose just because Jenny Gilruth mentioned Miscarriage of Justice organisation, who I know, I've met with a couple of times, know them well. Members will know here that Willie Rennie, for example, is the director, and met with him as well on occasion to discuss the good work that Mojo do. I'm not sure that we would say that they would help victims of crime. They do help victims of another sense, of course, miscarriages of justice. So whether they would fall into the criteria of the draft guidelines, I'm not entirely sure that they would. However, as I say, we're trying to make this as open as we possibly can. So the criteria is designed to be as open, but at the same time, it is victims of crime. And remember, it is the surcharge is coming from those offenders that have had a court fine imposed upon them for committing a crime that has a victim at the other end of it. So again, I'm not focusing on Mojo, but yes, I would think it would have to help victims of crime specifically.
Thank you.
And John.
Good morning, panel. Cabinet Secretary, I know you said in your opening statement, and again repeated, that you would be happy to share the draft guidance. Are you able to give any outline at all as to what might and might not be covered? And in particular, the issue of counselling of victims, is that something that you imagine that financial support would be provided for, please?
Yeah, the guidance will give a little bit more detail on that, so when we share it, of course, I'd welcome feedback from members of the Justice Committee. Counselling would exactly be the type of support that could be covered. I suppose the kind of one important caveat around the victim surcharge, so I'm talking about making it as open as possible. I suppose the one caveat to that, which is quite important, is if other funds are legally obligated to assist a victim of crime with something, then those funds are the ones that the victim should go to first. And then the victim surcharge, if it's not covered, should then be able to come in and help. That would, therefore, the victim surcharge isn't just plugging a gap that, for example, home insurance should cover, or the DWP should cover, or a housing association should cover, for example, broken locks. That would often be the responsibility of the housing association. It shouldn't cover that gap, but it should cover where there is genuinely a gap. The member will be aware we have funeral grants, for example, and so on and so forth. We've got other funds that exist. So the one caveat would be where there is a legal obligation on another institution or organisation, they should be the first port of call. But it could be the case that the exception to that, I'm just going to almost contradicting myself here, the exception to that would be, you know, the victim surcharge can be disbursed, I think, relatively quickly. So within victim organisations could do it within 48 hours, whereas, for example, a housing association might take longer to fix a lock. So in that case, I think, you know, we'd have to be very open and very flexible.
If I may push you then on the counselling, that's reassuring. You would imagine that's something that's a statutory obligation on the NHS to provide. Are you saying that? How does that square?
Yeah, I'm not sure there's a statutory obligation on the NHS to provide counselling for victims of crime per se. I mean, obviously there can be referrals from a GP, particularly if it's a particularly traumatic crime. Somebody might well be. I worked for the late Bashir Ahmed, and when he was an MSP, he was the victim of a mugging, I remember, and that had a really profound effect on him. Relatively low-level offence. You know, he thankfully wasn't too injured. You know, and takeaway didn't get too much off him. But you know, that would be an example of what we might call a low-level, relatively low-level offence. And these things are all relative, of course. That you wouldn't necessarily get NHS counselling for, but I know it shook Bashir at the time, and so that might be for that individual actually relatively traumatic, and they might want to speak to somebody about it. So where the NHS might not be able to cover, or to give my previous example, it would take a while because there might be a waiting list, there might be other priorities above them, then it is possible that the Victim Surcharge Fund would cover that. So, I mean, I'm trying to be as open as I can to the member. We are genuinely looking to ensure that we're not restrictive with the fund, but where there is a legal obligation for others to provide assistance in emergency situations, then they should go there first, so that the money from the surcharge can be used as widely as it possibly can to fill some gaps.
Thank you.
Shona.
Good morning. In your opening statement, Cabinet Secretary, you talked about the funds and the estimate of how much that will be. I think you said something around 800,000 after 4 or 5 years. So it was to get a little bit more information on that. Is that an estimate based on full recovery, or does it take into account non-payment of some of the penalties, for example? Because obviously that's going to impact on the level of the fund. So it would be useful to know what that is based on. And would that be actual payments made? So if the fund is 800,000 per year after 4 or 5 years, would you expect all of that money to go out each year, or would that be a kind of running total? And when do you expect the first payments to be made?
Yeah, thanks for the questions. The figures are estimates, and I suppose it is important to kind of put that on the record. They are estimates, so they're not absolute. absolutely scientific, but they're based on the collection rates that we currently have. Remember, will be aware not only is it court fines, but it's also compensation orders at the moment. So it's based on the collection rates, which are relatively high. I think I said in the question to Liam Kerr, around about 88%. But we want them to obviously be higher. So based and modelled on kind of current collection rates. In terms of our question around after 4 or 5 years, we estimate 800,000 being in the fund. Yes, we'd expect that money fully to be disbursed to organisations, but it does depend on the level of applications that come to us. If the applications are not to that level, then of course we wouldn't disburse all of that money. So it does depend on the level, but I don't suspect that there would be any difficulty for organisations coming forward for the amount that we have. Forgive me, her last question was?
It was about the how quickly the payments will go out.
Yeah.
First payments.
The plan is to allow 6 months for accumulation of funds, and then from 6 months from the fund coming into force, then we would expect the first payments to be made. So we would expect it to be in, if you call it late spring or early summer next year.
Okay. Could I also just go back to something that Mr. Tuck said earlier about the costs, because presumably that fund is after costs have been covered, and you mentioned the 135,000 for the Scottish Court and Tribunal Service. You said something along the lines of there'd be a separate income stream to cover that. It wouldn't be from the surcharge. What would be that separate?
So that would be from Scottish Government funding. So rather than taking that from out of the surcharge fund, which is obviously there to benefit victims, that would come from other core grant funding, so it would be separate.
Okay, so the any money raised for the surcharge is essentially money that would go out to victims, right? Okay.
Thank you, Convener. Yes, I was going to ask about the effect on victim support organisation administration requirements, but that's been answered in an earlier question. So I'm aware that this is part of a much wider programme to support victims of crime, and I'm just wondering, are there any precedents to this? Does any other country do this?
Yeah, I mean, England and Wales have a surcharge fund. And so there'll be other examples of other countries as well. I suppose the point to make is this is one tool in a whole suite of measures and whole suite of measures that we have to bring forward. And we have brought a number of positive changes to victims, and I think that's been recognised. And this committee has played an important role in that in terms of legislation. But the Victim Surcharge Fund, we know from victims will go a long way in the very practical impacts of what they have to deal with, particularly for some of the most heinous crimes that are committed. So, you know, think about, we have homicide statistics out today. You know, for those families of those victims, you should not have to worry about funeral costs on top of dealing with the grief and the trauma you're already dealing with. So I think this will be an important tool in our support for victims, but it is just one tool and as I say, a whole suite of measures that we look to bring forward.
I'm sure it's a very welcome one. Thank you.
Fulton.
Pardon me. Thanks, Convener, and good morning, Cabinet Secretary. I'm just wondering how the Scottish Government will ensure that communities across the country can benefit from this in the different localities, because obviously we know that rates of offending and types of offending can be different in different places.
Yeah, it's an important point. I think, frankly, the only way to do it is to monitor it. Within the guidance, we do ask around the geographical area, the draft guidance at the moment, and of course, again, I'll share that, but we'll ask the geographical area that your organisation provides support to, that will allow us to monitor what geographies are covered. So there'll be some national organisations like, again, Victim Support Scotland, who will have an interest. And having known VSS for my time as Cabinet Secretary for Justice and even before, I've been to their conference with their volunteers, and they cover a very wide and geography. So you do have national organisations. I think for us, we're very, very aware, cognizant, and we'll keep a close eye on the geographical element to it, because, you know, there'll be certain expenses and costs that you would incur being a victim of crime in an island community, for example, that you just would not face if you were in Glasgow or in any of the cities on the mainland. So we just have to, we'll certainly be aware of it. We'll monitor it closely, and I think if there are geographic kind of gaps that exist, we'll have to have words with, maybe in conversations with organisations that are in those areas that are gaps, and see if we can encourage them to apply to the fund.
Okay, Cabinet Secretary, I wanted to also ask about, have the government done any analysis on the potential impact on sentencing, given the restorative nature of this? So, please excuse my voice. So perhaps around where, pardon me, no, I should get this in. Apologies. So perhaps where, it's a cold that's been around my whole house, so perhaps where sentencers, sheriffs perhaps are thinking about giving out one community disposal, has there been any analysis done if this, if the introduction of a surcharge, as I say, given the restorative nature of it, could perhaps impact on sentencing and perhaps even impact on sentencing, custodial sentences?
I'm not sure. I don't think there's anything to suggest in the modelling and the work that we've done that this would shift sentencing behaviour from sheriffs or judges. There already exist some orders, so the member will be aware of things like compensation orders, for example, that exist, and there's not a suggestion, certainly that I've seen, but I'm happy for officials to tell me otherwise, that would suggest that there'd be a shift in sentencing behaviour. Remember, this is related to court fines, and court fines can also be applied to where there are CPOs and the like as well. So I don't see there being a particular shift, though I understand the logic of why he's asking the question. I certainly haven't seen any modelling. I've just looked to officials to see if there's been anything that's been done that they're aware of that would affect Sharivo behaviour. No,
but again, it's something that we'll monitor.
Yeah, and keep an eye on
forward.
Okay, thanks.
Just to conclude, Cabinet Secretary, given that there may be some concerns about the geographical spread of the fund, in monitoring this, is it something that the government might consider in the future relinquishing its administrative role to someone like VSS once it's been up and running, you're satisfied that the process is working properly? Is that something that might be considered in the future?
I always keep things under review, but I'd be keen that victims' organisations, even the size and scale of VSS, who are capable of administering and running funds, just concentrate on that element. Plus, organisations, I expect VSS to be around for, of course, a very long time, and we're happy to support them and fund them for a variety of different projects. But of course, organisations can come and go, and we would we want to ensure that there's stability for any fund like the Victim Surcharge Fund, which is so crucial and so important for victims. But I'm not ruling out when it comes to review. I think we should always be open-minded to see how we can ensure we're getting the best out of any funds. But I don't envisage it, I should say, changing in the near future.
Okay, thank you for that. Agenda item 4 is formal consideration of the motion in relation to the Victim and Witnesses Scotland Act 2014, Supplementary Provision Order 2019. The Delegated Powers and Law Reform Committee has considered and reported on the instrument and had no comment on it. The motion will be moved with an opportunity for formal debate if necessary, and the motion is motion 19058, that the Justice Committee recommends that the Victim and Witnesses Scotland Act 2014 Supplementary Provision Order 2019 draft be approved. Cabinet Secretary to move?
Moved.
Right. Do members have any further comments? No. And the question is therefore that motion 19058 in the name of Humza Yousaf be approved. Are we all agreed? Agreed. We are agreed. Agenda item 5 is formal consideration of the motion in relation to the Victim Surcharge Scotland Regulations 2019. The Delegated Powers and Law Reform Committee has considered and reported on the instrument and has no comment on it. The motion will be moved with an opportunity for formal debate if necessary, and the motion is motion 19059, that the Justice Committee recommends that the Victim Surcharge Scotland Regulations 2019 draft be approved. Cabinet Secretary to move?
Moved.
Thank you. Do members have any comments? No. The question is therefore that motion 19059 in the name of Hamza Yusuf be approved. Are we all agreed? Agreed. We are all agreed. That concludes our consideration of these affirmative instruments. Committee's report will note and confirm the outcome of this debate. Is the committee agreed to delegate the authority to me as convener to clear the draft report? Agreed. Thank you. I thank the Cabinet Secretary and his officials for attending, and suspend to allow for a change of officials. Agenda item 6 is consideration of an affirmative instrument, which is the Proceeds of Crime Act 2002 Investigations, Code of Practice, Scotland Order 2019 draft. And I welcome back Hamza Yusuf, Cabinet Secretary for Justice, and his officials, Alan Nicholson, Proceeds of Crime Policy Advisor, and Isabel Joyner, Director of Legal Services with the Scottish Government. I refer members to paper 5, which is a note by the Clerk, and invite the Cabinet Secretary to make a short opening statement on the instrument.
Convener, for the opportunity to speak briefly about the Draft Proceeds of Crime Act 2002, Order 2019. Section 410 of the 2002 Act requires Scottish ministers to prepare, consult on and publish a code of practice on the functions of the proper person. A proper person is defined at Section 412 of POCA as a constable, officer of HM Revenue and Customs, or an immigration officer in relation to confiscation of money, or confiscation or money laundering investigation, or B, the Scottish ministers or a person named by them in relation to a civil recovery, detained cash, detained property or frozen fund investigation. This order proposes to bring into operation a revised code of practice for the exercise by proper persons in Scotland of the investigative functions conferred on them by Section 380, 382, 387, 397 and 404 of POCA. These sections provide respectively for the exercising of orders and warrants in relation to production orders, orders to grant entry, search warrants, custom information orders and account monitoring orders. These orders and warrants allow the proper person to require an individual or company to provide information that is of a significant value to an investigation, or indeed to search for such information. The powers allow the proper persons to fully exercise their functions under Chapter 3 of Part 8 of POCA. A code of practice has been in operation for 16 years and last revised in 2009. While there's been no material change to legislation that would require a reissue of the code, we have taken the opportunity to strengthen the code, which makes more comprehensive and enhanced guidance available to proper persons. The revisions simply include more detailed guidance on each of the individual orders, including procedures for serving orders and the copying and retention of materials. The new code also includes more thorough advice to proper persons on legal privilege and on the statutory requirements needed for customer information orders and account monitoring orders. In conclusion, this will provide additional guidance for practitioners on how to comply with the requirements in exercising their functions under the 2002 Act lawfully, proportionately and consistently, and this will hopefully in turn provide confidence to the public that the exercise of those functions is carried out fairly and with integrity and respect. And of course, always happy to answer questions that members may have.
Thank you, Cabinet Secretary. Do members have any questions for the Cabinet Secretary? No. That being the case, agenda item 7 is formal consideration of the motion in relation to the affirmative instrument. The Delegated Powers and Law Reform Committee has considered and reported on the instrument and had no comment on it. The motion will be moved with an opportunity for formal debate if necessary. Motion is Motion 19219 that the Justice Committee recommends that the Proceeds of Crime Act 2002 Investigations Code of Practice Scotland Order 2019 draft be approved. Cabinet Secretary to move.
Move, Convener.
Thank you. Do members have any comments? The question is that the motion 19219 in the name of Humza Yousaf be approved. Are we all agreed? Agreed. We are all agreed, thank you. That concludes our consideration of these affirmative instruments. Committee report will note and confirm the outcome of the debate. Is the committee agreed to delegate authority to me as convener to clear the draft report? Thank you. Can I thank the Cabinet Secretary and his officials for attending and suspend to allow the Cabinet Secretary and his officials to leave. And item 8 is consideration of 2 negative instruments, the enforcement of fines relevant penalty, Scotland Order 2019, SSI 2019/280, and the Victim Surcharge Fund prescribed relatives, Scotland Regulations 2019, SSI 2019/282. I refer members to paper 6, which is note by the clerk. The Delegated Powers and Law Reform Committee has considered and reported on these instruments and has no comments on them. Is the committee agreed that it does not wish to make any recommendation in relation to these instruments? Agreed. Thank you. Agenda item 9 is consideration of 2 legislative consent memorandums relating to the Sentencing Pre-Consolidation Amendments Bill and the Domestic Abuse Bill. The bills touch upon devolved matters, and the Scottish Government is recommending that this Parliament gives its consent to the UK Parliament to make the relevant provisions in the bill. I refer members to paper 7, which is a note by the clerk. Do members have any comments? Okay. Are members agreed that the Scottish Parliament should give its consent to the relevant provisions in the Sentencing Pre-Consolidation Amendments Bill? Agreed, thank you. Are members agreed that the Scottish Parliament should give its consent to the relevant provisions in the Domestic Abuse Bill? Agreed. Thank you. That concludes the public part of today's meeting. Our next meeting will be on Tuesday, 12th November, when we will hear closing evidence from the Cabinet Secretary on the Scottish Biometrics Commissioner Bill. We now move into private session.